Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Most of us know someone who was injured in an accident or was a victim of medical malpractice. Today we'll try and educate you as to what constitutes negligence and look at how much time you have to bring a lawsuit, how to choose the location of your lawsuit, and why so many cases settle. Our guests are the Honorable Michael Garson, Justice of the Supreme Court, Kings County, and Ben Zalman, my partner of over 20 years, and Ben has over 35 years of trying negligence cases. Hello, Judge Garson.
Good afternoon.
Hello, Ben.
Alan?
Judge, let me ask you this. Why does one case settle and one case go to verdict? What's the difference? What makes up a good settlement?
What makes a good settlement? The two lawyers that know on both sides of the case that what their case is all about and what they feel their case is worth, and decide that it's best to have a bird in the hand than 10 in the bush.
Yeah, but I know you give recommendations many times to both the plaintiff's lawyer and the defendant's lawyer. How do you come up with that magic number that settles the case?
There's never a magic number. All it is trying to get a feel for what the plaintiff really will accept as his bottom line, and what the defense counsel's firm will pay, or the insurance company behind them will pay to get rid of this case, so that they don't have to allow 6 people in Kings County to decide their fate.
Ben, when is the best time from a plaintiff's point of view, from the injured party's point of view, to settle a case?
You mean the apex? The point at which, well, every case is different. There are some cases that should be disposed of fairly early on, and for a lot of reasons. There may be reasons having to do with the client, maybe reasons having to do with the investigation, the testimony, and there are times when you might get a decent offer early on, and it's worthwhile to the client to have the money earlier than having to wait 2 or 3 years.
But for the most part,
for most part, however, the problem is, on most cases, is that no one really talks seriously until the case is ready for trial. And it takes 2 or 3 years from the time of the accident to the time that you get into the courthouse and are assigned to select a jury or a part. So there's a time delay, there's a time process. And unfortunately, most cases, the best time to settle the cases from the point of view of money is at that point. Would you agree with that, Judge?
I agree that the best time is to settle a case when the case is in the courthouse, ready to go, just at the point where jurors are to be selected. That's probably what you said was the apex, or the best time to dispose of the matter.
Do you find that many times the insurance companies, before they put meaningful dollars, will actually wait till after you select the jury?
I think most insurance companies hold back on their meaningful dollars until they ride the case to the end, and the end being when it arrives in the trial assignment part. And that although there are some companies now that are talking about giving you their best dollar shot up front, and that it's always going to remain that, I don't find that to be true.
Do you find there are different personalities to companies, that one insurance company will settle easier than another insurance company?
Absolutely. Absolutely.
What's been your experience?
My experience is that there are the companies that are in court every day, that working on a low overhead budget, would rather dispose of their matters before they get in deep with heavy administrative costs for trying the case, or producing their own, having their own doctors come in and testify. There are some companies that just have a philosophical viewpoint that it's best to settle than it is to allow jurors to tell them how to settle it.
Now, Ben, when a client asks you, what is my case worth, what do you tell them?
I never tell them a dollar amount. I never tell them a dollar amount.
But how do you know what their case is worth?
After a certain amount of time in the business, you have a sense. There is no magic number, as Judge Garson said, to any case. And every case is different. It could depend on the personality of the client, the extent of the injury, the type of recovery they had. And when a client comes in and says, you know, a friend of mine down the street got X dollars because they had stubbed their toe and they were injured, I said, that's fine, but that's the person down the street, it's not you. You're unique, your case is unique, your case has a unique value, and I can't judge in advance nor tell you that your case has a dollar sum worth X dollars, because unfortunately, okay, if we can't get that sum, client is disappointed. If it goes beyond that, it's another story. So I try not to give them a dollar sum. I try to tell them that they have a good case, they'll get a good result, we get as much as we can for the client.
Judge, I know you as a trial judge have the authority to either, once a jury brings in a verdict, to raise that verdict or even lower that verdict. What criteria do you use to override what a jury says?
Let me interrupt for a second, if I can. Most people don't understand that. They don't know that. What they see is these big verdicts in the paper. They don't know that the court has the ability to raise or lower their decision on cases when they are out of line.
More time than not, a judge will leave the verdict the way it is. But there are occasions where, at least in my courtroom, where I felt that the jury missed the point as to who was at fault during causing the injuries of the accident, whether they apportioned the case correctly. And if they missed that, then I might raise the verdict decision if I felt that the plaintiff was entitled to more, because I felt that the plaintiff was really not that responsible or as much responsible as the jury thought them to be. More often, though, you find that you will lower the verdict if you do anything to it. And that after a verdict, at least in Kings County, after a verdict comes in, if you felt that the verdict was excessive in comparison to verdicts that have been brought before the appellate division and reduced, you might enter into that factor into what you decide to do at the end of the case. But most times I'll leave the verdict the way it is.
Now, Ben, what happens on an appellate level? You started talking about it. When the case, a jury comes in with multiple millions of dollars, what often happens?
Well, I don't know about often, but of course we have an appellate court that oversees what juries do. And if a plaintiff or a defendant is unhappy with the amount of money that's been awarded, they have a right, if Judge Garson doesn't do anything with that verdict, to go to an appellate court and say the jury paid too much or the jury paid too little, and they have the right to adjust it. One of the problems that we're facing today as a bar is that I think jurors as a whole have been affected by what I consider to be a tremendous amount of propaganda that's been issued by insurance companies. Everyone talks about runaway juries, and you read in the paper about verdicts that come in at numbers which may very well be astronomical, and they consider those to be real numbers. They're not. We all know that those numbers are not real numbers. Those numbers are eventually reduced for the most part. On the other hand, there are numbers that come in that seem to be astronomical, and most people consider those numbers to be for pain and suffering, when in fact they are really compensation to take care of people who have been tragically injured and require an extensive amount of medical care for the rest of their lives, which could be 30 or 40 years. And if you take a look at the costs involved at maintaining these people, the issue really is who's going to bear the burden, the party who caused the injury or the general public. And what's happening in the courthouse is that jurors today, I think, have been affected by the propaganda, and they come in with a negative attitude towards people who have been seriously injured and are entitled to be compensated because of someone's fault.
Judge, let me ask you something. You deal with jurors every day, as Ben said. Are there certain jurors who are more favorable to the plaintiff and certain jurors who you see are more defendant-orientated?
Yes, I mean, on any particular case, there are jurors that you can weed out your hunches that they're more plaintiff-oriented or more defendant-oriented. But I think it really boils down, at least what I've seen, is that insurance companies, defense counsels, they know what a case is worth and what a case should settle for. And they spend a lot of money in their claims department educating their claims examiners to put what they call a reasonable value on any particular case. I always tell defense attorneys, don't allow 6 or 8 jurors from Brooklyn who have no particular education in the field that they would like them to have it, decide their fate. I think that juries are, on the most part, more liberal than conservative in Kings County.
Now, I know that certain insurance companies are actually using computer programs to come up with dollar values of what they will put on the case. Has that been successful?
No. I think that some of the insurance companies are saying that it's successful, but I don't really think so. I think that the computer is only as good as the person who mans the computer and puts and punches the boxes that comes up on the screen. And what's happening is that they're entering the data and they're taking a very sterile approach to what the case should be worth. And they have to adjust that later on anyway when it comes down to trying to settle the case. They are trying more cases based upon their computer results, but they're not factoring in yet the administration costs to try these cases. They say that they're reducing their verdicts because they're winning more cases and they're paying out less. I'm not so certain that that's going to be the bottom line figure when they add up all the expenses to have the lawyers there and all the witnesses and the medical testimony that they need, and they factor in those costs and they merge them together, whether their bottom line is still going to be as good as they think it's going to be.
So I shouldn't go out and start buying insurance stocks just based upon these computer programs?
I don't think so.
Ben, let me ask you this. Let's start getting some information to the public. If I'm involved in an accident, how long do I have to bring an action?
Well, in the general personal injury action, we have a statute of limitation that allows you to start a suit within 3 years of the time that you had the accident.
And if I fall down on a city sidewalk, or if I get hit by a city bus, what do I have to do?
Well, with the city, you have a special situation. First of all, you have to file what's called a notice of claim, and that notice of claim must be filed within 90 days of the accident. And then you have a period of 1 year to bring the lawsuit. So you have different limitations.
That's 1 year and 90 days.
1 year and 90 days, yeah. 1 year, 90 days after, 1 year after the 90 days. So that.
And Ben, when should a client contact a lawyer after an accident?
As soon as possible. As soon as possible.
On the night of the accident.
If not before.
No, as soon as the client is able to, because in many cases, and in some types of accidents, you're going to want to investigate the accident. You want to investigate the event. You want to be able to get that police report as soon as you can before it's filed, because there's a whole procedure right now. It's a double of a time to get those reports once they're filed in Albany. And you want to be able to contact the witnesses to the accident as soon as you can to get a statement while their memory is still fresh.
Judge Garson, now you're sitting in the city part in Kings County. Are there anything unique about a judge sitting in the city part as opposed to a non-city part?
No, except you're only dealing with one defense attorney or one organization that's defending cases in the city part, the City of New York or the Transit Authority, or anything related to the City of New York. The cases that come before me have been placed on a trial calendar, though, much longer than cases are on the trial calendar in the regular trial assignment part, because the city is so far behind.
So it just takes longer to reach your day in court if you have a case against the city?
That's correct.
Okay, we have to take a break now. We're going to continue with this information about the city right after the break. I'm Alan Schnorman, your host. You're watching Law Line. Stay with us.
Someone they don't know a gift. They do it because this gift saves lives. And the need for it is desperate. We need over 20,000 people to give this precious gift every day. Please give blood. There's a life to be saved right now. Call the American Red Cross at 1-800-GIVE-LIFE.
Thousands of women will lose a child to AIDS simply because they didn't get an HIV test when they were pregnant. You see, there's now treatment that can help stop the spread of HIV from mother to baby, which gives children of HIV-infected mothers something they never had before: a chance. If you're pregnant, please get an HIV test.
Hello, you're watching Lawline. Today we're talking about what constitutes negligence. I have Judge Michael Garson, Supreme Court Justice, Kings County, and also my partner, Ben Zalman. Judge, what does constitute negligence? What makes someone negligent?
Someone failing to do a duty that they owe to another person. We all owe people around us the duty not to interfere with their space, not to do anything that causes them to be injured in any manner. And if you violate that, or you don't live up to that duty, you breach that duty, you've created a negligent condition.
Now, I know you're sitting in the city part in Kings County. How is the city negligent in, like, providing safe streets?
Well,
If they are.
They're supposed to maintain the streets of the city of New York. It's very difficult to do that. There's a prior notice law in the city of New York that requires the city only to be responsible for defects that, at least when it comes to a broken sidewalk, those things that have been noticed or the city knows about, that's been reported.
So the sidewalk in front of my apartment building, that's not owned by my apartment building, that's owned by the city of New York.
Well, it might be. Let's assume that there is an area in front of your apartment building that might fall within the building line that your landlord might be required to take care of, but most of the sidewalk would be the responsibility of the city.
So if the city sidewalk is broken and the city has notice of that break, I can sue the city.
Absolutely.
You can sue the city if they have the notice of the break, right?
Well, that's what he said.
Right.
And Ben, how do they get this notice?
But the notice, how do they get the notice? For the most part, there's an organization that's called the Big Apple Pothole Corporation that in fact takes maps of the city streets, and they have people going out and noticing those defects that are significant enough to create a hazard or a trap for people who are walking by. And those maps are then filed with the city. They're filed with the appropriate party, thereby giving the city notice that these streets, which are on the map, contain these particular defects. You should take care of it. That they take care of it is another problem. I don't know that those...
They don't generally take care of it.
Judge, what
They do.
about snow and ice? If it snows, does the city have any responsibility to clean the snow and ice, or is it the homeowner or the apartment building owner?
The city imposes a responsibility on the homeowner or the owner of the apartment building to clear the sidewalk. If the homeowner chooses to do nothing, then the homeowner might not be responsible if somebody slips on the snow and ice in front of the premises. But if the homeowner takes on the duty to clear the snow, as there's required by law to do, and they do it in a faulty manner, and then somebody is injured because they didn't clear it properly, then that person could sue the homeowner.
Can the city ever be responsible?
Sure.
How would the city be responsible?
Well, if the city owns the property and sends out their own maintenance people to clear it. There are plenty of buildings that the city clears themselves. They clear every school. They clear around every school.
Judge, what about potholes? I'm driving my car and I hit this huge pothole and it breaks my front axle. Can I bring
the
it?
curse.
Can I bring an action against the city of New York?
Yes, but if that pothole hasn't been reported, then
Again, that prior notice.
that prior notice, you won't have grounds to stand on, and you won't be able to maintain an action against the city.
The problem, I think, is that that I don't think the Big Apple reports potholes unless they're in the crosswalk.
No, they don't.
So that you have a situation there where it's like a catch-22. They require prior notice, but notice is not generally given by the pothole, unless some nice little old lady comes by, sees it, writes a letter, and sends it to the appropriate agency in the city of New York.
Or the city actually caused that particular defect.
You want to know this prior notice law that came into effect only about 15, 17 years ago. This is not something that exists for a long time. Prior to that, you could sue the city if there was a pothole, but the city doesn't fill all its potholes, and there were so many lawsuits against the city that they were able to pass a bill through the city council, sort of like limiting their liability.
Now, Judge, you're sitting in the city part. For Kings County, you're the CHAP judge, the trial assignment part judge for the city. First, does the city settle cases?
Yes, but not for what the case might be worth if it were in a city case.
Why is that? Is the city any different than any other defendant?
They shouldn't be, and they shouldn't be treated that way, and they're not in the part, but their ability to offer money is limited by the layers of the political offices that are behind them, and they're not as free with their settlement money as some of private companies are.
So, in other words,
Pure tax dollars.
As far as settlement is concerned, many times a city case will settle less because it's the city as opposed to a private insurance company.
I would say most times the case would settle less if you sue the city of New York or a city municipality as opposed to having a private insurance company.
Which may be one reason why the city part is so backed up.
Do you find that...
No, that's not the reason. I think the reason the city park's so backed up is that I don't believe the city has the adequate amount of personnel to process all the cases that are brought against them, and certainly not enough lawyers to try the cases.
Well, in York County, how long does a city case take to come to trial?
About 22 months.
Which is more than a regular case.
Regular case now, if you put the case on the calendar, probably about 7 months you'd hear your case.
Do most cases in the city part eventually settle prior to verdict?
Yes. Most cases in all parts generally settle prior to verdict.
But including the city?
Including the...
Actually, what percentage of the cases, Judge, go to verdict where the jury actually has to say?
A very small percentage. Less than 5% of the cases, I would say, go to verdict. Most cases, if you're counting all cases that are filed at the courthouse, most cases are settled prior to trial. And most cases that go out for trial are settled during trial. And so it's a very small percentage. I don't have the statistics at my fingertips, but you can realize that there's probably 100,000 cases floating around the civil part of the courthouse in Kings County.
That includes the city part as well?
That includes the city part.
Right.
And there's in all judges, there are only about 50 to 60 judges that can try cases on the civil side.
Right.
So,
and you have hundreds, if not thousands, of cases.
You have thousands of cases. Every judge has at least 1,500 to 2,000 cases.
And it would be impossible to try 15 to 200,000 cases.
You can't. It's just 52 weeks a year. If a judge was able to try one case a week, which is an impossibility. Some cases are only 2 days, but most cases take a week or longer to go to verdict. Would only allow
50 cases.
50 or 52.
Out of over 1,000 cases.
Without allowing for sickness, vacation time, or holidays.
The cases that do not settle...
Can I just say something? Because I think that that's an important point. You know, people talk about the jury system, and the jury system has been bashed. But if you really think about it, it's really a compromise system that we have. The jury system is there, and a small percentage of cases are resolved by the jury. Yeah, but for the most part, they are resolved by compromise.
But that's right. But if you don't have jurors present, you can't get the attorneys in the compromise mode.
There's a whole movement now to bring in what they call alternative dispute resolution, ADR, into the court system. How do you feel about that?
I'm not for it in the court system. I know about it, and of course it does alleviate a lot of the problems that for backup in the court. If you want to bring your case there, that's a whole different way or philosophy of filing your suit and resolving it. If I'm a litigator, And I think litigation should be brought in the courthouse. And if you're not afraid of litigating a matter, you bring it before the court, you have a judge decide it, and the jury decide it.
Let me ask you a few other questions, Judge. I'll put you on the spot. The Chief Judge is trying to get rules through now, one where the charge, the law, is actually written out, as opposed to now, which is given orally to the jury. It's given orally. She wants to get it orally written out, and where they could actually take it into the delivery room.
I think that that's bad. In my opinion is the system we have is good. Let the judge read the charge, let the judge be the controller of the charge, and not give a cold statement to the jury for them to analyze while they're in the jury room and try to read into that charge things that the judge might not have said.
And the same suggestion, on the same note, she wants to have the juries being allowed to keep their own notes. How do you feel about that?
I believe that's a good idea. I think that jurors do get lost during a trial, and if notes helps them, that's fine. They should use it for refreshing their own mental thought.
Well, what happens when one juror takes a note and the other juror, maybe 2 out of 6 jurors take notes? Well, their notes now are down on paper, and what they say...
Let them resolve it in the jury room. They're resolving their thoughts in the jury room anyway, so they're not really doing anything different by resolving their notes. It's just, some people are more meticulous about taking notes than others, but I think it's a good idea. I think it would help the deliberation process, and that we would have less confusion in the readbacks. And of course, if someone said, no, that's not what I understood it to be, they could always call for a readback.
Judge, there's a whole controversy now, merit selection against the electoral process of judges. Many people feel that judges should actually come through a screening process and then be appointed either by the governor or by the mayor, as opposed to now, which is a hybrid system. Some judges are appointed, and many judges, like yourself, are elected by the population. How do you feel about that?
I am firmly for the election of judges, just like I am for the election of my own congressman. I would not want a screening committee to determine who my public officials should be representing me. I think that when you have screening committees, I think that they're good to allow the parties to determine who their candidates are, but I think ultimately the public has a right to choose who they would like to sit on the courts based upon philosophy or whatever hunch they have about the candidate. By giving it to strictly to a selection committee or a politician, a single politician or a board, you're just giving away the different group of people who are choosing. In a selection process, who is going to make up the committee? Which politician is appointing his friend to that board so that that board will then recommend somebody to the person who has the authority to select, and then that person becomes the...
Of course, the critics say now that there's too much power in the county leaders, who basically control the delegates to the judicial conventions, who nominate the judicial offices, and in New York City, Democrats far outnumber Republicans.
So that the convention system should be open for change. Maybe there's a different system of selecting not through a convention, the particular candidate. Maybe there should be primaries for all positions. But strictly a selection system is only, when you say a county leader, I don't know what really that means. I know it's the leader of a particular party, but we do have a bi-party system in this city and in this state.
And with that, I have to thank Ben Zalman. Thank you very much for appearing on Lawline once more. And Judge Michael Garson, thank you for coming on Lawline. And as always, this is Alan Schnorman. Thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.